Hello, it's Dr. Bechtel. Hope you're doing well. And this is a lecture for the sources of the law cases. This for my students is from Chapter 3 of Introduction to Law. And the authors will be given at the end of at the last slide in the references list. So we're going to talk first about this lecture involves the sources of the law that are cases, case law. We begin then with a quick discussion of judicial restraint. And the United States Constitution was an effort of creating a government of laws and not men. And so it allocates the authority to three branches of government. And this way we can have a checks and balances system between the executive, legislative, and judicial branches. And to be clear, this is case law that we're talking about, and so we're talking about the judicial branch of the law. Chief Justice John Marshall and U.S. Supreme Court and the U.S. Supreme Court, they established two fundamental principles we're going to talk about next. These principles define the role of federal judiciary, and that is judicial review, stemming from the Supremacy Clause, and the power of the court to examine legislative and executive acts. So those other two branches of the law that were mentioned in the previous slide. Because judicial restraint is founded on those two, on the other hand, judicial restraint is founded on the ultimate authority that resides in the court, and it's made up of judges appointed for life in the United States Supreme Court. And so it's necessary that judges restrain themselves from actively entering the political arena. This comes from the Marbury versus Madison case from 1803. And Marbury versus Madison is a landmark case from the United States Supreme Court, where Chief Justice John Marshall famously declared that a law repugnant to the Constitution is void. It established the principle of judicial review discussed in the previous slide, which is the power of the Supreme Court to strike down laws that are in conflict with the Constitution. The opinion of Chief Justice John Marshall emphasized that the United States Constitution is the supreme law of the land, and that it's the judiciary's duty to interpret and uphold it. And the case didn't just resolve a dispute over a judicial appointment, which involved the Secretary of State of the United States at the time. It's an interesting story. It reshaped the balance of the power among the branches of government and gave the judiciary its defining role in the Constitution, in the interpretation of the Constitution. It's literally the foundational moment in American legal history, and it still echoes through every constitutional law class and courtroom today. Legal authority is what we're talking about when we're talking about cases and other types of law. Legal authority is, if we're going to make legal arguments, we need to find case law and other sources of law. But since we're on case law, I'll stay right there. The arguments we're making in the case, we're looking for analogous cases, similar cases, and we'll be going into that. In another class, actually, legal research and writing, we spend a lot of time talking about what an analogous case is. Common law is an American legal system foundation that came to us, and it was inherited from England. And it becomes a lot more than simply English law. And American jurisprudence, common law refers to judge-made law. Therefore, judges do make law. This slide indicates that part of the American democratic folklore is that judges only interpret law. However, that is untrue. They do, and under that first point, they do not make law. It's a fallacy. They have the power to interpret law. It inevitably leads to making law. So as a case is interpreted, and it inevitably will make new law. Also, when faced with a novel or difficult case, judges occasionally formulate statements of law, and these form important new principles of the law. And again, judge-made law falls into this category. Stare decisis is, simply put, let the decision stand, meaning that when the court is faced with novel fact, a novel new fact situation, and it formulates a rule to decide the case, and then in that case, the court sets a precedent in that case. The force of precedent depends on the court that hands it down. We're going to look at this in a couple of slides. Precedent is considered binding, meaning it's a mandatory that the courts below it must follow it. Think back to the Marbury versus Madison case, where Chief Judge Marshall said that the United States Supreme Court law is the supreme law of the land. That's precedent. That is the idea of precedent from that level of the United States Supreme Court. Precedent is what dictates judges should follow prior precedents, prior decisions, when they're making decisions in cases. Stare decisis also requires that the same rule be applied in future cases with identical fact situations. And that's hard because virtually every case will differ in some way from preceding cases. And our legal arguments, therefore, commonly revolve around comparing facts of an instant case, the case that we may be advocating for, with the previous law called precedents. And arguing against application of precedent is also possible in cases where the case entails distinguishing, which is what we mean by distinguishing cases of the instant case with those of precedent. And so we look for similarities and differences, and these differences would be a distinguishing mark on the case precedent. So I'm looking at one case, wanting to apply it to another, to the case at hand. I would need to, either make the assertion that it should be applied the same as in previous fact pattern situations, or I could distinguish that case by saying not this but that, but it's still the same, or it shouldn't be applied at all. And oftentimes that falls around the factual background of the case at hand. It's important to also recognize while we're on this journey that adjudication and legislation are different. Judges may be said to make law, but they do so differently than legislators do. Adjudication is particularized. It focuses on particular events and particular parties. And legislation, on the other hand, is generalized, and it's designed to make rules that apply to everyone. More on adjudication, we're looking at a narrow focus on past events. It's the process, adjudication is the process of judges making decisions to resolve disputes between parties. And they look through a magnifying glass at one case, and they declare what law is applicable in that case. And if a law is made in the process, it just happens to be a byproduct of the case. So I hope you're seeing still that weaving in of judge-made law, and also the function of the judge in an adjudication versus legislation. We have a judge. So the judge in adjudication will settle the dispute, and rather than determining how law applies to other cases in the future. So that's a narrow focus on certain events, and hang on. So there is a narrow focus to settle the dispute based on precedent, and that's an adjudication. That's the function of the judge. Legislation is different because it has a universal application and a future effect. And I really like the way the text I'm using in this class explains this. So the characteristics of adjudication, of legislation, excuse me, turn on my little pointer, is it has a universal application and a future effect. Remember, it's generalized to the entire population for the most part. Legislators don't resolve an individual case, although they can codify case law for future effect and generalization across parties, across situations. The legislative process is typically one that operates first by recognizing the problem and then attempting to solve it by enacting law. We call this law statutes. And again, that universal application and a future effect. It wouldn't have past effect. The legislative process, when it's complete, law becomes a matter of public record, and everyone must comply or risk whatever legal consequences are involved. Okay, my apologies. Obiter dictum. Obiter dictum is a Latin term, and dictum by itself, these are found in case law. You're reading case law and you see that the judge writing the opinion has remarked or given an opinion and comments in the case decision, and they exceed the scope of the issues and rules that decide them. It's not binding on future cases. And this is an important part of legal research, or I should say legal reading, is looking into the language of the case to determine that it was a holding, which is what we find in case law, holdings that describe the legal outcome of a case. And but the dictum is more of anything outside of the rule of law that's used to determine the legal and factual issues that are presented in the dispute. Anything outside of the reasoning and rule behind this case language is dictum. And it's something to learn how to identify, and you learn that through legal research and writing class. Legal authority consists of state and federal constitutions, statutes, and judicial opinions. And the reasoning that comes from authority is to arrive at a reasonable solution, and the court will use the best authority it can find. The legal rules also apply the court system also supplies information to the legal researcher. And we're looking for precedent, and we want the most value out of our precedent. And again, our precedent is a legal authority. So to understand the cases that are more valuable, which means the difference between mandatory, meaning the court must follow this rule, versus persuasive, meaning the court may follow the rule, you have to understand the basic structure of the courts in the jurisdiction, whether it be state or federal court system, where the cases were decided. And jurisdiction also applies in the reading in the decision on using cases, because it means the power of a given court to address or act on a legal issue. These powers are provided in a geographic context as well as a subject matter context, meaning that geographic, I don't need to explain that, but subject matter meaning the area of law being decided. And in other words, different courts will handle different types of cases depending on their subject matter. We also, though, have trial courts with the broadest jurisdiction, and these we call general jurisdiction, meaning they have a variety of matters that that trial courts have jurisdiction over. And it also takes into these trial courts also take into account the amount of money in controversy, and also we also have trial courts of limited jurisdiction. And I'm supplying this to just show you the precedential value. We'll get into these other areas of jurisdiction later on when we go into civil procedure. But the trial courts, they have the broadest jurisdiction. It's general jurisdiction. Moving to the mid-level appellate courts, they have the precedential value increases, and once it gets to the court of last resort, like in Marbury versus Madison, it becomes a supreme law of the land, meaning that it has a high precedential value because it gets higher up the court pyramid. As we learned in Marbury versus Madison, kind of the same topic, top court is the boss. In federal cases, we're going to look at the next slide, it'll talk about state cases. And it's very much the same, but I'm wanting to illustrate it for both. Imagine this is your pyramid. And, well, it's not really the pyramid, but imagine this, we're researching state law. We're looking for state law in our state. And it has, because that will have more precedential value than the case law from another state. When we get to the mid-level appellate courts, we look into the geographical jurisdiction. And then we have precedent from SCOTUS, which is the Supreme Court of the United States, and it's generally a mandatory precedent for all constitutional questions. Here at the mid-level appellate courts, their decisions require you look at these geographical jurisdictions. So those in your geographical area will have the most precedential value, which makes it mandatory precedent, meaning all courts that encounter a similar problem will need to follow the same precedent as that followed in the mandatory precedent already established. Those in the federal court, and we're still in federal, but those in the federal circuit in which your case is located will also have mandatory precedent. Now, this is going to be a little hard to understand until we get to the court system, but the idea here is to show you a couple more times than once how this works in the legal authority framework. And then cases from circuits in the federal system that are outside of my case's location in the court the court, if I'm looking for case law, I want one within my jurisdiction, in my own state, so that I have in my own circuit from the mid-level appellate courts will have persuasive precedent in your jurisdiction when we go outside of that. So those geographical boundaries are extremely important to understanding where the boss is as far as the top court, the top precedent. The most value to the precedent comes from the top court. When we move outside of that, like in this case, we do only have persuasive precedent. So the courts in the state cases, the courts work the same way. I won't really go into too much repetition, but when we're in state courts, the top court is the boss. So in Florida, that would be the Florida Supreme Court if you're in Florida. Every state has their top court. So we have mid-level appellate courts in the state court systems, and these also follow the same guidelines. We're looking for things in our geographical area. Those will have the most precedential value, and then we'll have mandatory precedent where we have the mid-level. When we're in that mid-level, the same, because they're geographically organized, and the same thing happens. These courts, if you're in that court, and I have an example coming up which is going to help explain this a little more. So only cases from the mid-level appellate court for your jurisdiction will have mandatory precedent. And of course we have mandatory precedent with the Supreme Court. So this is like a hierarchy. I'm trying to describe a hierarchy with these arrows. Cases from mid-level appellate courts outside of my case's location, that's going to be persuasive precedent. We also have situations where we have non-binding authority. And then sometimes we use law from sister states when we cannot find some precedent with binding authority, like we talked about. In binding, just think of that as mandatory. And when that's absent, we go look around to other states, and the decisions of other state courts are often, they're always persuasive authority. And it's important that we be careful using law from sister states. And examples abound, but I like my Wyoming example. When I lived in Wyoming, we would often look, we didn't have as much law. There is no law in Wyoming. That's one of my favorite sayings. And we would use the laws and case law and even statutes, legislation that is, from Colorado. It was our sister state, had a lot of similarities to us. It was close to us, just south of us, and had similar industries, similar climate even. I've mentioned in another of my videos the notion that, like I'm using the example of fruit trees. Well, I wouldn't find a fruit tree growing in Wyoming unless it was in a greenhouse. So I probably won't find, like I will in Florida, agricultural statutes or cases about agricultural issues involving orange groves, for example. I won't find that law in Wyoming, but I will find it in Florida. Similar to my, contrasting that with my Wyoming-Colorado example. You know, it snows there, and things that happen in the snow are much more likely to be the same in each state than in the Sunshine State with Florida fruit trees. So as promised, I do want to look at this a little bit more closely. I think there's, hold on a minute, I think something's wrong with my slide here. Oh, there it is, okay. There we go. This case is important in Florida. Its name is Pardo versus State. It's a criminal case, and in the and what they found in 1992, and this is a Florida Supreme Court case, is that when there's interdistrict conflict, such as between the intermediate courts of appeals in Florida, the court decisions will not bind all Florida courts unless there is a Supreme Court of Florida decision that solves that issue. So the district courts of appeal, that's an intermediate court in Florida, they're required to follow Supreme Court decisions. But it may not, there may not, this is part of the predictability of precedent in the law. And so trial courts are going to be required to follow those holdings in higher courts as well. Those are the district courts of appeal. The proper hierarchy of decisional holdings would demand that the event only, that in the event the only case on point is on a district level, intermediate, okay, district level, is from another district. These are geographical districts, as discussed earlier, other than the one in which the trial court is located. So the trial, if it's outside of that district, the trial court will follow that decision in their geographical area. But let's say there's another decision that's different in another county or trial court in another geographical district that's totally different, then that district is going to need to follow that entirely different rule, even if it's entirely different. However, if they get to the Florida Supreme Court, the Florida Supreme Court basically solves the bet. Then all trial courts and all the intermediate courts follow the same rule as the Florida Supreme Court. So that goes back to that top court is the boss, and it applies in state court in this way. And the comparison you could make is the United States Supreme Court, Supreme Law of the Land, that's a federal situation, and then in Florida courts, which is a state situation, that there's no interdistrict conflict, meaning there's not different decisions among the 6 district courts of appeals. we would follow what's in the Supreme Court. If there's nothing in the Supreme Court, and even if there are conflicting decisions among those district courts of appeal, that goes geographically down to the trial court. So again, we're back to that structure of the court system defining it. Case law is a source for three types of legal rules. So generally, there are two types of cases. As mentioned earlier, you heard this term earlier, interpretation. Cases interpret and apply another source of a legal rule, such as a constitution, an administrative regulation, or a statute. So this is what the judges are doing. They're interpreting and applying a source of legal authority. Cases that rely on and develop legal rules, however, fall into common law. And this is an area where our students learning this tend to get confused. Common law is case law, but cases relying on and developing legal rules contained only in case law is not interpretive application of the courts. Instead, it's judge-made law, or also common law. But interpretations, as noted earlier slide, can also result in judge-made law. So cases, we have two things. Case law is interpretation and application of another source of a legal rule, like a constitution, an administrative regulation, or a statute. And cases that rely on and develop legal rules contained only in case law. We don't have any legislation, we have no regulations, we have no constitution to handle this. We call this, judges will use common law to solve those problems. And in the meantime, a byproduct may be making new law. The case itself, which is the court's decision, or the holding, is yet another form of legal rule. It's a court's conclusion about how a legal rule applies to a factual situation. And it is a full statement of the court, and a full statement of the court's holding necessarily references the law and the facts, in either case of interpretation or in judge-made law or common law. There are different categories of cases. Case law is a source for three types of legal rules. Kind of repetitive, but I want to drive this in as best I can. How a legal rule applies, case law is a court's decision on how a legal rule, whether it be, how a legal rule applies to a set of facts. So common law is going to apply to a legal rule from a past case, and only states have common law. There is no such thing as federal common law. Case law applies legal rules from statutes, administrative regulations, or constitution, and likewise applies rules from those sources. I realize this is repetitive, but this can be confusing for people. Within all these cases, there's always a holding, and this is the one time in law that we actually get to see law made. The decision of a specific court is the case holding. So the court holds how the legal rule applies to a set of facts. Common law. So again, we talk about this a lot, so we're differentiating everything. But common law, as said before, is judge-made law. And Black's Law Dictionary defines common law as the rules and customs that do not rely whatsoever on the legislature. These are, again, imported from English case law. They can be either civil or criminal. However, most states have codified or codified, whichever way you want to pronounce that, have codified, meaning place this into legislation, the criminal law of the state. Decisional law, or judge-made law, it's going to be the one that relies on precedent, or otherwise called prior court decisions. Common law abounds in areas of law such as torts, property, and contracts. Now, we also have non-binding authority, and these would be one example is secondary authority. Your textbooks in school, those are secondary authority. You get the black letter law out of there. It's black letter law, but it's not going to apply necessarily in Florida or Wyoming or any other state, but it might. Black letter law is this vast, and secondary authority, like your textbook, can include treatises, law review articles, restatements of the law. And these are used in arguments by lawyers and opinions by judges that are not officially law. So secondary sources are not officially law. They can be cited to if it's a safe bet, but generally speaking, secondary authority is really good for getting you up to speed on what you need to know about the general area of law, and sometimes it's even a complex area of law. And these sources, such as law review articles, treatises, and restatements, will help you better understand it. And by the way, within those secondary sources, there are citations to mandatory authority that you can go down the rabbit hole and find. We also have non-binding authority in the form of unpublished cases. So the judges decide whether a case needs to be published or not. So they'll deem that case as unpublished, and it doesn't appear in an official printed reporter. What this means is that many jurisdictions, they're unpublished, and many don't have any precedential force within them. So I hope that's not too much. It's an area of case law that needs some attention. You'll get it over and over in your law courses. This is a foundational effort, and my references are on the next slide. This is the Phillips, Margaret, A Practical Guide to Legal Research and Analysis for Paralegal and Legal Studies Students. And we also have the book I use in my course, Ransford Pyle, 2017, Foundations of Law, Cases, Commentary, and Ethics. I actually think there's a second author on there that I have not included, so I'm going to fix it. All right. So thank you for listening. Take care.